Get started here right now. So thank you for joining us for this second part of an EPCRS corrections webinar. Your presenters today are Eileen Ferenzi and Tim McCutcheon. For those of you who don't know Eileen is the managing partner of Ferenzi Benefits Law in Atlanta. Ms. Ferenzi advises clients on all types of employee benefit plans, particularly focusing her practice on qualified retirement plans, benefit issues and mergers and acquisitions, and advising third-party administrators of employee benefit programs on technical and practice issues. Having become an attorney after more than 10 years as a third-party administrator, she brings a unique and practical approach to her advice. She's a member of the state bars of Georgia and California and holds designations as a certified pension consultant from ASPA, an accredited pension administrator from NIPA. Eileen is also the author of our qualified plan e-source on ERISApedia.com. Tim McCutcheon is the publisher of ERISApedia.com and president of Vermont Compliance Labs. Tim is the founder also of ftwilliam.com, the most innovative document and government forms provider in the industry. He wrote the first web-based 5500 forms package and introduced the first retirement plan document e-sign system. Tim is a member of the IRS Great Lakes TEGE Council and a former member of the Information Reporting Program Advisory Committee of the IRS. Prior to founding ERISApedia.com and ftwilliam.com, Tim's law practice included counseling TPAs, financial service companies, and other benefit service providers regarding qualified plan, product design, and compliance. Tim received his JD cum laude from the University of Wisconsin-Madison. He is also a CPA and holds an MBA degree from the Kellogg School of Management at Northwestern. So we're going to start the presentation now, but remember you can download the slides on the control panel that you should see from GoToMeeting, and you can also go to our website, ERISApedia.com, and under the masthead webcasts, you'll be able to download previous presentations as well as register for upcoming presentations. My name's Chuck Gouge. I'm the facilitator today to kind of get this thing going. Our question board moderator is Joanne Pacina, so if you do have a question, you should find a place on the control panel where you can type your question in. Joanne will keep track of them, and hopefully we'll have time to answer them in the presentation, or if not, we'll get back to you with an answer afterwards if we can. So let's get started. A couple of things we need to remember is that your lines are muted. So please do send in questions via the control panel if you would. And if something were to happen and you didn't get it asked during the webinar, you can always send a question in to support@ERISApedia.com. So take it away, Eileen.
All righty. Good afternoon, everybody. Hope you're doing well. I guess there's some people for whom it's not afternoon yet, but at any rate, our agenda today is that we're going to talk a little bit about what we covered last time. We're not going to spend a huge amount of time on that because that's what we had the first seminar for, but to the extent that somebody either has a short memory or that you weren't able to make the first webcast, we're going to give you just a little bit of an intro. We're also going to then talk about a whole series of errors that we are going to give you sort of what the normal correction is. I just want to remind everybody as we go into this whole session that there is no one correction for most of the errors that you have to do. There's a lot of flexibility, and so there are times that the correction that is in the EPCRS procedure or that we talk about today won't work well for your client, and you should consider the idea that you might want to approach the IRS with your alternate correction and see if they would accept that, because on many occasions that works really well. So Tim, if we can go to the next slide. Okay, so part 2, here we go. So here's our quick review from last time. There are 4 things that can cause a plan to be disqualified. There's a plan document failure, which means that something is supposed to be in the document and isn't. The IRS shows really what needs to be in the document in the various pieces of guidance they do for document providers. And so something is missing from the document that needs to be there. It could also be that you have something in the document that the IRS does not permit. The second kind of failure is an operational failure, and this is where I see probably something like 80% of what goes on. And the definition of operational failure is that whatever you did administratively was not in conformance with the terms of the plan document. The IRS thinks, and I think there's some reasonableness to this, that since there's a written document requirement, it's more than just having a document in writing, is that you have to follow what the written document says. The third type of plan disqualification failure is a demographic failure. Under a demographic failure, the plan works the way it's supposed to work. You're following the terms of the plan. You're doing everything right. But because of coverage or non-discrimination or 401A26 participation failures, you're not passing those rules. And so you've missed a situation really just because of the demographics of your employee group. And then finally, an employer eligibility failure is when a company or an organization sponsors a plan that they are not permitted to sponsor, such as a governmental organization sponsoring a 401k plan, which is permitted, or for-profit organization, or the wrong kind of nonprofit organization sponsoring a 403b plan. So EPCRS is the acronym for Employee Plans Compliance Resolution Program. It is the procedure that the IRS has issued for how to fix boo-boos. The latest version of this is Revenue Procedure 2016-51. It's really, I think, an interesting procedure. It's got a lot of information in there. And I've said many times, and I want to repeat today, that if you do administration and you don't have that on your desk and it's not, covered with coffee stains and highlighted and 3-hole punched and all that other kind of stuff, then you're really missing out on a really valuable tool for helping you fix mistakes when they happen. So under EPCRS, there are 3 kinds of correction programs. There's the self-correction program, which some people refer to as SCP, which allows you to fix what they call insignificant errors anytime that you find them, and you don't have to get the IRS involved. If you have a significant error, it is time limited. You can fix it within the period of time that is the end of the second plan year following the plan year in which the error occurred. And so if you have an error that occurs during that period of time, no matter how significant it is, you may self-correct that. For purposes of ADP and ACP testing corrections, you have a year to make those corrections, and so the 2-year period starts at the end of the year following the year in which the ADP or ACP testing error was applying. And then you have the voluntary submissions to the IRS, which is generally referred to as the Voluntary Correction Program, or VCP. You do a filing using Forms 8950 and 8951. Your plan can't be under examination, and you submit it to the IRS. You pay them a user fee, and you come to some negotiation how to correct. And then finally, the Audit Closing Agreement Program, or CAP, is the program that gets used if a defect is found under audit. So I mentioned that if you're outside the self-correction period, that 2-year period, you can only self-correct if the error is insignificant. This slide shows you the various factors that the IRS balances to determine whether you have a significant failure or an insignificant failure. One of the key takeaways I want you to have from this slide is that if you are outside that 2-year period, it is a subjective analysis that the IRS goes through, and so you'll never know for sure if you really are insignificant. So if you can get errors corrected during that 2-year correction period, that's the best way to do self-correction. Next slide, please. There we go. VCP, as I mentioned, the plan sponsor submits a plan to the IRS for some sort of coordinated correction program. There is a user fee that's payable. The user fee shows up not in the EPCRS procedure anymore like it used to. It shows up in the normal revenue procedure that gets issued every single year by the IRS to show you the various qualified plan-related fees. The plan has to be eligible for the program, and there's a series of eligibility requirements. And basically everything gets happened after the approval is granted. You get what's something called a correction letter. Audit cap, the IRS discovers the problem. You enter into a let's make a deal kind of discussion with them where they help you figure out how they want you to correct the problem. You pay a sanction that's negotiated and is based on a series of factors, and then you sign a legal document that is honestly a contract with the IRS where they promise not to disqualify the plan and you promise to fix the problem the way that you've said. Okay, so when we're framing corrections, which is really what this session is about, there's some basic issues that you really should know about, and so that's what we're going to talk about now. First of all, you should know that the revenue procedure, and I just realized we have an old revenue procedure up there. You want to use the 2016-51. I don't know how that got through all of us looking at this slide, but it's 2016-51. The procedure contains pre-approved correction methods for some errors. So if you have an error and the IRS has addressed that kind of error in the procedure and you correct it the way that they say, you know it's safe. Again, though, you're not obligated to use those methods. You can bring forth other reasonable, appropriate methods as long as the IRS thinks they're okay. And so when you're going to do that, you want to look at the correction principles that are discussed in EPCRS to determine whether or not the kind of correction you're doing is appropriate. You want to use the code, regs, and EPCRS as a guide in framing those corrections. And remember that if you have discrimination failures, what you need to do is correct that by giving more to the NHCEs. You can't take away money from HCEs usually because that would be a violation of the anti-cutback rule. So normally what you have to do is push up the NHCEs rather than taking away from the HCEs. And then keep in mind as you're framing corrections that the further and further that you get from a pre-approved alternative, the more it's important to ask the IRS for approval. That basically you're getting more and more risky the further away from the pre-approved solutions that you are. These are the correction principles that the IRS looks at to determine whether or not your proposed correction really is reasonable. And they're really important to take into mind. The first one is that you have to correct all taxable years, even if they're closed. Basically, what I will tell you is that there are going to be times where your clients don't want to correct all years, that they only want to correct certain years, and that means that they're going to maintain some risk of disqualification based on those years that they don't correct. If you're doing a VCP correction, generally speaking, you're expected to do all of the taxable years. There may be some finessing around that, but you really should talk to somebody about that if you don't want to correct for all years. They want you to basically have a correction that restores the plan and the participants to where they were had the failure not occurred. They want the plan to end up looking as much as possible like it would have had the plan operated correctly. There are situations where you can convince the IRS to do something different than that, but that's kind of sort of where you want to start from. Again, the correction should be reasonable and appropriate, and that the examples that they give you in the appendices to the procedure are all deemed to be reasonable and appropriate. You don't want to choose a correction method that violates another section of the code. So for example, in order to fix a coverage mistake, what you do is you do something that would violate the non-discrimination sections of 401A4. You can't be doing that. You got to do something that would be acceptable under the code as well. Generally speaking, as I mentioned, if you have a situation where the NHCEs are being discriminated against, you're going to stoke up their benefits as opposed to taking anything away from HCEs. The IRS prefers solutions that keep assets in the plan. So if there's money that's been allocated to somebody that shouldn't be, what they want you to do generally is forfeit it rather than removing it from the plan. There are times where you have to take money out of the plan, but that's not their main preference. And then finally, if you are working on something where there's a crossover between the IRS and the DOL, they will consider what other agencies are doing. So if you have a situation, and we've had this many times, where a client is in review by the Department of Labor, and we come up with a solution with the Department of Labor, we want to make sure plan qualification is taken care of as well. We'll do a VCP submission and tell the IRS that DOL has already approved this, and that usually smooths the way with the IRS as well. Excuse me. There are some exceptions to the correction principles, and when you're looking at those, what you really need to note is that it's just never acceptable to have an adverse effect on participants that isn't to put them back in the position they would have been in. And what I mean by that is that you're allowed to take things away from somebody's account if they were not entitled to that to begin with. But the IRS does not want you to come up with a correction procedure that what ends up happening is that the participants end up being harmed by your correction. Usually a correction is going to go in the direction of helping participants. And again, you can't come up with a correction that has a discrimination in favor of the HCEs. Sometimes you're supposed to reallocate stuff, and you're going to want to reallocate things differently. I'll tell you right now, one of the things that the IRS is going to look at in your alternate allocation is, are HCEs more benefited by your change than they would have been otherwise? And if the answer to that is yes, you want to think of a way to temper that so that you don't have to say to the IRS, well, yeah, our proposed correction is going to dump a whole bunch of money in the HCE's pockets, because that will tend to have you not approved. you cannot basically be successful by going to the IRS and saying, this is the way we need to correct. We have this problem. It lasted for, 10 years. Oh my God, we can't get all that 10 years worth of data. It's going to take time. It's going to take energy, and it's just too hard for us. And, all that kind of stuff. The IRS does not accept as a reason for doing something differently the fact that it's going to be too much work for you to do the things right. That just is not an acceptable reason to change their direction. Now, there are times where it is truly out of whack what you would have to do. I mean, if you have a very large plan and it's going to involve, 3 years worth of research to find that somebody got an allocation of $12 too much, that's something that the IRS can usually get their arms around. But what I'm saying is that in a normal situation, whining to the IRS about how much work a corrective process is going to be is not usually going to be persuasive to them. The IRS lets you use estimates for things if the cost of the precise calculation outweighs the probable difference, or if the precise calculation is not possible. We had a case, for example, where we needed to reallocate a bunch of money, and the fund holder record keeper who had done the original allocations had done them off their system on like a spreadsheet, and the spreadsheets had been lost. So there was no way for us to identify the exact elements of these calculations. So we did the best that we could on an estimate to figure out what people were supposed to get, and we worked on that with the IRS, and we came out with an acceptable estimate process to figure out who was due what. If you have a situation where somebody's supposed to get more money, and the amount that they're supposed to get, and this person's gone, by the way, so they're eligible for a distribution, and the amount that they're supposed to get is going to be $50 or less, and the cost of you processing a distribution is more than the amount they're going to get, you can just not do it. You can ignore that. Similarly, you have to, or importantly, you have to take reasonable actions to locate lost participants and beneficiaries. And this little acronym down here is TIMS, and it took me a while to do it, but what it stands for is, what would you do if it was your money? I'm very proud, by the way, Tim, that I figured that out all by myself. You must make people whole for lost earnings. So if you have to do a corrective contribution or a corrective allocation or distribution, people have to get earnings between the time that the money should have been either given to them or put into the plan and the time that that actually occurs. If in truth the investments lost money in that interim period, you do not have to reduce the amount you're giving them for those losses, but you can if you would like to do so. And you can also do some assumptions about the date on which earnings begin. For example, if you have a contribution during the year that you make, like a profit sharing contribution, you can start with the date that the contribution would have been allocated to the person's account. And if you're doing something like salary deferrals or after-tax contributions or loan payments, you can assume that everything that would have been done during the year happened at the midpoint of the year, because that's sort of rough justice of when all those monthly contributions would have gone in. The preferred way to determine earnings is to base them on the employee's actual investment choices. There are times where you don't have that. Sometimes the employee was accidentally excluded, so they've never made investment choices. Sometimes the person's investment choices change really often, and so to identify the exact earnings is a little bit difficult. In circumstances such as that, you can do reasonable estimates of investment returns. If you have multiple investment options in the plan, one of the choices that you can do is that you can assume that the option that you're going to use is the one that has the highest rate of return, because that will give most of the employees more than they would have gotten otherwise, and that's a good thing. Needless to say, if most of the people who are affected are HCEs as opposed to non-HCEs, that might not be acceptable. And if the employee has made no investment selection, you can do a weighted average of all the investment options and come up with that, so that basically the idea is that the employee is going to get the average of what all of the similarly situated employees actually earned. A common question is, can we use the DC's or the DOL's VFCP calculator? You can use that on occasion. It is not favored by the IRS, and so you need to really talk to them about that. And again, you have to do it in such a way that it's compelling, because their initial response is going to be, you really need to do something based on what people actually earn. So you need to have some reason why coming up with actual earnings is going to be overly burdensome, or why it's not possible because you don't have information that you should have. Okay, so the first error we're going to look at is situations where you were supposed to put somebody in the plan and you forgot to do it. So you either forgot to enroll them or you forgot to enter them into the plan. So the correction is different depending upon whether you're in a 401k plan or not in a 401k plan, and it's also different depending upon whether you have automatic enrollment or not. So let's start out with the easiest situation. The easiest situation is that you have a DC plan, say a profit sharing plan or a money purchase plan, and the employer has forgotten to put somebody in the plan. So option number one would be that the employer contributes enough to give the participant the contribution, the forfeiture allocation, the earnings, as if he or she were properly enrolled in the plan. So everybody else got a 10% of pay contribution. You assume that you would have increased the contribution to give this person 10% of pay as well, and you give them the 10% of pay. Another possibility, though, is particularly in a profit-sharing plan, let's say you have a pro rata allocation formula, the idea would be that, hey, if I had put this person in the plan, everybody else would have gotten a little bit less, and this person would have gotten their allocation. So if you wanted to, you could actually redo the allocation and adjust everybody's accounts so that the proper allocation goes to everybody, so that the other people are not overstated and the amount that goes to your excluded person is correct. That happens more often when you have a lot of people excluded than if you have one. If you've got, a 100-person plan and you let out one guy, and the choice is between making an adjustment for one guy and making an adjustment for all of those participants, usually they choose to do it just for the one person. Remember that if you do that second option, by its very nature, it's going to take some money away from people. So you're going to have some explaining to do. You're going to probably want to do some level of employee communications so they understand why this money is coming out of their account. Did you want to say something?
Option two, what if the profit sharing plan had an actual formula that said each person gets 6% of compensation?
Could you use in that case, you're in option one.
Okay.
I'm sorry, I interrupted you, sweetie. Sorry.
No.
Yeah, if there's a definite allocation that somebody should have gotten, then you need to give them that allocation. Okay. If you have a defined benefit plan, you basically give the person the accrual they're supposed to have gotten. It's pretty easy. So here's an example. ABC Company 401k plan operates on a calendar year with a monthly entry. Margaret was due to enter January 1/16, but the company forgot to enroll her. What do we do to correct her? Well, again, this correction depends really on whether or not the plan uses automatic enrollment. Now, one of the important things to remember on all of the corrections for 401k plans is that you have two things going on here. You have a situation where the person may or may not have wanted to defer. And then based on that, the person may or may not have gotten a match. And then, of course, there's a profit-sharing contribution potential as well. So one of the things that we have to look at is, well, this person didn't defer. What are we going to do about that? And so moving on, we'll see what we have to do. If we have an automatic enrollment plan, there's a special deal that says if you find out that you forgot to automatically enroll the person within 9.5 months after the plan year end, in other words, you find this by the extended due date of the 5,500, then what you need to do is to begin doing the correct deferrals based on the automatic enrollment by no later than the first payday on or after that 9.5-month period. On occasion, employees will come to you and say, hey, I thought you were going to automatically enroll me and you didn't do it. Well, if the employee notifies you, you have to begin the deferrals by the first payday for the month following the month where the employee notifies you. You can't dawdle around for 9.5 months in that circumstance. You must provide a written notice to the employee, and that has to go out within 45 days after the correction begins, the correct deferrals begin being taken out. And if you do all that, then basically you will not have to make any contribution at all for that employee that replaces deferrals the person should have made. But what you will have to do is calculate what their deferrals would have been had they been automatically enrolled pursuant to the plan terms, calculate the matching contribution that would have gone in for those deferrals, and you must make that matching contribution plus any earnings that should have been accrued on that matching contribution. So let's say that we automatically enroll at 3% and that we have a 50% match on that amount. So we would have had that person get a 3% contribution during the period of time they should have been enrolled. That person is not going to get any money for that 3% contribution, but they would have gotten a 1.5% match on that contribution, and that amount we have to put in. That actually has to be contributed within 2 years after the plan year of failure. And again, it must have earnings all the way up there. Now, this special deal, the IRS feels very strongly about, because the reason for this deal is that people were saying we're not using automatic enrollment because the cost of correction is so high. So the IRS has said, sort of in the same voice that your mother used to say to you about quit playing around in the back of the car, or I'm going to pull off the side and smack you all. They say if we don't see an increase in automatic enrollment plans by 2020, then we're going to take this away, because clearly that's not the problem. So, you guys better get out there and sell some automatic enrollment plans between now and 2020, or else.
Eileen, we've got a couple of
Yeah.
questions if you'd like to take them now.
Sure.
Okay, the first question is, and this goes back just a few minutes here, is the $50 distribution fee a stated amount? If the distribution fee is $100, is it acceptable? Is that an acceptable de minimis as far as not having to give a terminated participant who has already taken a full distribution another contribution as part of the correction?
Okay. The $50 is a set number. So the most that you can disregard is a distribution you would otherwise have to make of $50. So if somebody's supposed to get $58, you can't disregard it, even if the cost of the distribution would exceed the $58 or the $53, whatever I said. So yeah, the $50 is a set amount. Now again, when you are working with the IRS and VCP as opposed to a self-correction, you could discuss that with them, and they might come to another agreement with you. But for self-correction, this is the only pre-approved estimate that they have on distribution amount.
Okay, and a second question: a plan has a a plan has money purchase money that was merged into a 401k plan in 1996. The money purchase money was not aggregated, and no J&S waivers were obtained for distributions. Is there any feasible correction for this, as it appears that several of the spouses or employees who obtained distributions are deceased?
Okay, so the way I understand this, we've paid out a bunch of money that should have been subject to QJSA waivers, that they never got the waivers, and it's been a really, really long time, and some of the people are dead, and so it can't be corrected. I mean, the technical answer that one would give is that you have to try to do corrections, at least for the people who are still alive. I think that if the participants and the spouses are dead, I think you're done. But to the extent that you have participants who got money that they shouldn't have, you have to at least write a letter discussing the fact that there should have been a waiver from the spouse and try to get that waiver at this point in time. And then technically, if you don't get the waiver, then you do have to provide the QJSA or the QIPSA to the spouse after the participant has died.
Okay. And then we'll take one more question, then I'll hold some more as we're having a few more come in. Has sample language been provided for the notice that needs to be provided to the employee if deferrals are not started timely?
The IRS did not provide sample language, but they did provide information about what has to be in the notice, and I believe that's down the road in the slides. So we'll get to that.
All right.
All righty.
Okay.
So now, sorry, I keep talking over people. I apologize. It's my enthusiasm. Okay. So now we have a situation where somebody didn't get enrolled, and we do not have automatic enrollment. So in this particular case, we're going to have different rules depending upon whether you catch it quickly or whether the catching it is delayed somewhat. So let's say that you were supposed to enroll me in your plan, and we find out within the 3-month period following the first enrollment date. If we do that, and then again, we start making the correct deferrals by the first payroll date on or after the 3 months, or on or after the month after I've notified you that you haven't been doing my deferrals, and you give me the notice again within the 45-day period, again, I don't get any contribution to make up for my failure to have deferrals taken out of my account. We are going to contribute the missed match plus earnings. Now, what is the missed match in this circumstance? If I did do an election, my mismatch will be based on my election. If I have not made an election, in other words, this wasn't a situation where you forgot to implement the election, it's a situation where you forgot to enroll me entirely, then my match is going to be based on the average rate of deferral of people in my group. And by my group, I mean if I'm an NHCE, it's the average rate of deferral of NHCEs. If I am an HCE, it's the average rate of deferral for my HCEs. So if on average the non-HCEs have been deferring at the rate of 4% of pay, then my matching contribution will be based on what I would have gotten as a match had I also deferred 4% of pay. And again, you are going to have to give me earnings of some sort. Next slide, please. There we go. Now, if we don't find the problem until it's after the 3-month period, but we do find it within the 2-year self-correction period, the last day of the plan year, 2 plan years following the year in which the deferral error occurred, then we do have to make a qualified non-elective contribution that reimburses me to some extent for the deferrals that I never did get. Okay, and the QNEC is going to be 25% of whatever the missed deferral was. Again, the missed deferral is going to be equal to either the amount that I had elected to defer that you forgot to take out of my paycheck, or if I've made no election, it will be 25% of the average rate of deferral for the group of people that I'm in. Okay, so again, let's say that everybody on average was deferring 4% of pay. That would mean that you would put in a QNEC for me of 1% of pay for that period of time, 25% of the 4%. You then would have to calculate the matching contribution I would have gotten on the full deferral that I would have made, either based on my election or based on the average rate. So that would be the 4% that I was just talking about. You calculate the match based on that, and you must contribute that match as well, plus earnings. Okay, so again, just to say this one more time, that you have to put in a 25% QNEC based on what my deferrals would have been, and the full match plus earnings. If you're outside the self-correction period, then no safe harbor applies at all, and the QNEC is 50% of the missed deferral. That's the rule that's been in place for a number of years now. Basically what they've done is they added those lesser amounts for the earlier discovery. So you would make a contribution equal to 50% of what we would have expected my deferral to be. You'll contribute the full match based on 100% of what my deferral should have been. Earnings on both of those things. You still got to give the employee notice when you start doing the correct amounts, and off you go. Again, I mentioned this before, and it's on here again, but it's basically if you don't have any elections, then it's either the automatic enrollment percentage or it's the average rate of deferral of the similarly situated employees. Earnings, again, I've talked about this a little bit. It would be based on either what the employee would have earned on his or her investment choices. If we don't have investment choices, and if mostly NHCEs are affected, we could use the highest earning fund for the period of the failure. If the employee did not make an investment choice, you can use an average rate of return for the plan as a whole. And perhaps if you have very special circumstances, you could convince the IRS that the VFCP rate was reasonable. Can you self-correct the error? In general, any of these things are self-correctable. The only problem would be if you're outside the self-correction period, or if the error is found because the IRS notified you of an audit and you were preparing for the audit, so you've already got an audit notice. Then you'd have a problem doing self-correction unless you could show that to the IRS that this was a de minimis or an insignificant error. And it's hard to imagine a situation where they would find not making deferrals for somebody in a 401k plan would be an insignificant error. So again, would it still be self-correctable under audit? You can be if it's insignificant. If it's a significant error, it can be corrected within the 2-year period, but if an audit would terminate that self-correction period. So if it was a significant error, you'd have to do it under CAP. Again, these are the factors under which the IRS judges whether something is insignificant. There are, let me read them out here because it's really important. First of all, do you have any other failures? The IRS likes plans that have a culture of compliance and that, this mistake, whatever it is that they found, was just an isolated boo-boo. So if you have a situation where, the only thing correct on this plan is the name on the 5500, you're less likely to have the IRS treat it like it was insignificant. They want to look at the percentage of plan assets and plan contributions that are involved. If you have teeny tiny dollar amounts, it's much more likely to be significant than if you have big dollar amounts. How many years are affected? The next bullet is important to look at because it's 2 elements that they look at. They look at the number of participants affected as a percent of the total in the plan, as well as the number of participants that are affected as a percentage of those who could have been affected. So let's say you have a plan that's got 10,000 employees in it and you missed 100 people. That looks really insignificant. But if those 100 people were the only ones who became eligible this year, so you missed 100% of the people who could have been affected, it is less likely that the IRS will deem that to be insignificant. Did you make correction within a reasonable time after discovery, or did you dawdle around? And also, finally, why did the failure happen? And what they're looking for there is that you had procedures in place that should have caught this, and because of some, human error, this particular isolated incident occurred. And this is basically what I just said. So let's move on. Can you use forfeitures to make corrections? The answer is yes, if the plan provides that forfeitures reduce employer contribution. If you're supposed to reallocate forfeitures, they cannot be used for corrections. And there used to be a lot of concern about using forfeitures to make up missing QNEX and safe harbor contributions. That concern is gone. The IRS has new proposed IRS regulations that lets you do that. So you don't have to sweat about that anymore. Okay, did you have anything you wanted to say about any of those corrections, Tim?
No. Sounds good.
Hard to get a word in edgewise with me, isn't it?
Yeah.
Okay, let's move on to the next error, which is bad loans. Can we go to the next slide? There we go. So the GHI company's 401k plan does not permit loans, but when the TPA takes over the administration in 2017, we find out that there were 3 loans granted to participants during 2016 in violation of the plan. Oh my God, what to do? Before we go to the next slide, I just want to note that you may be thinking, well, what's the big deal? But I want you to notice that what we have here is operation that does not follow the terms of the plan. Even though loan problems tend to be tax problems, when you don't follow the terms of the plan, that is a reason to consider the plan to be disqualified. And so that's why it's a big concern in this circumstance. Okay, moving on. So is this within the self-correction period? Yes, in my hypothetical it was. So how do we correct it? Well, the IRS has, within the EPCRS procedure, 3 different defects that you can correct by retroactive amendment under self-correction. So it means that you may, on your own initiative, retroactively amend your plan to fix the problem, and you don't even have to tell the IRS about it. And one of them is to retroactively add a loan or a hardship provision when you have historically not permitted loans or hardships, but somebody got them anyway. So that is really a great solution to the situation. You're just going to retroactively amend the plan to permit loans. So basically, at some point prior to the end of the year, GHI, or prior really to the end of the correction period, GHI company adopts an amendment to permit participants to borrow from the plan effective retroactively to January 1, 2016. Now, the question is here, does GHI have to open up loans to everyone for forever, or can we just purify the loans to these couple of people, because we really don't want a loan program? And the answer is, if the borrowers were NHCEs, that lending to them was not discriminatory, you could actually do an amendment that says we're allowing loans to Joe, Sam, and Sue, and nobody else, and then that will just justify the loans that were made. Or alternatively, you can offer them to everybody. If your borrowers were HCEs, you're going to have to open it up to everybody. Otherwise, it's going to be determined to be discriminatory. Okay, that was easy. Now we're going on to bad allocation. Bad. This poor dog looks so cowed. So JKL has a profit-sharing plan that has tiered allocations. Under the plan, forfeitures are allocated to participants who were there in the prior year and who are still employed at the end of the current year, but the TPA gave forfeitures to all participants from 2011 to 2014. So people got forfeiture allocations that they shouldn't have gotten, and the error gets discovered 3 years after the last bad forfeiture allocation was given. Can we self-correct this? Well, we really can't, because the error happened a long time ago, way outside the 2-year correction period. And since it affected everybody who was supposed to get a forfeiture correction, it is likely not to be an insignificant mistake that we can correct after the 2-year period. So if we really want to do this correctly, we need to file a VCP filing. If we don't file a VCP filing, what happens? Well, if there's no audit by the IRS, you're going to be fine because nobody's going to know. But if the IRS audits you and finds that you had a defect that was not self-correctable, but you did correct it, what they at least say in their speeches is that they give credit for partial correction. So that basically they would look upon you more favorably than they would somebody who had made no correction at all, because you clearly have a culture of compliance and you've done what you can do to fix things. On the other hand, they do not want to encourage people to self-correct outside the self-correction period. So what they would do is that they would put you into CAP, and they would charge you a sanction, and that sanction would be greater in general than the VCP fee would have been, so that they're smacking your hand for not having done the VCP filing. But at least theoretically, it will be more lenient than it would have been had you not done anything to correct and they had discovered this. So how do we correct this problem? Well, we have to put participants back to where they would have been had the allocations been done correctly. What we have here is that new entrants during the year received allocations to which they were not entitled, which means by definition that existing participants did not receive as much as they should have. So we've got some people overstated and some people understated. So what we should do in this circumstance, what the standard correction in this circumstance would be, is to do a recalculation where we allocate the forfeitures for all the years that were affected as if they were done correctly. And we take a look and see who got extra money and who got too little money. And we figure out what needs to be added and what needs to be subtracted from people's accounts. I recommend, by the way, that you do this to some extent where you do each year separately and then you accumulate it at the end, because what you may find out is that some people are up and down on various years and you end up net different than you would have been if you do it on a year-by-year basis when you make your correction. So we find out that over this huge year period, this guy got too much, this guy got too little, and you figure out what has to be done. Basically what you're going to do then is you're going to remove the overallocations and earnings from the accounts of the remaining participants, and you're going to allocate those amounts to the people who were shorted. And to the extent that there is a differential between those numbers for any reason, the company is going to have to make up the difference. One of the reasons why there might be a differential is that some of these folks may have been terminated and overpaid. So what do we have to do about them? Well, generally speaking, we have to send a letter to those folks and say to them, you got a contribution on this particular year or a forfeiture allocation that you weren't entitled to. So your account when you got paid was overstated by this amount of money. We would like you to please return that money. And oh, by the way, that money was not eligible for rollover to wherever you rolled it over if you did so. Usually employees, upon getting those letters, immediately throw them in the trash and ignore them. That's what everybody's expectation is that they're going to do, including the IRS's. So assuming that no repayment is forthcoming, again, the company's going to have to make up that amount of money to the plan. And in addition to that, you must send a love note to that participant who didn't repay the money with a revised 1099-R reflecting that the overpayment was not eligible for rollover. What are the earnings that you're going to do? Well, again, the standard is actual. If you can't do actual, then you need to do some consideration. And here's one of the problems. You remember me mentioning that one of the things that you can do is assume the highest earning fund. But the IRS is very concerned about the fact that while you're being overly generous to people who are getting additional money, that you don't be overly punitive to the people whose accounts are having money taken out. So if I'm using the highest earning fund and I go to your account and I remove $100 and I use that highest earning fund, unless you were actually invested in that highest earning fund, that correction puts you into a worse position than you would have been prior to the correction, over and above the fact that we took away your overallocation. So what we find that we end up doing is using two different earnings assumptions if we're not using actual earnings. One assumption will be on the high side, and that'll be for people who are getting money. One assumption will be on the low side, and that'll be for people whose accounts are being decreased by their overallocation. So we make sure that the participants are not being harmed. And then, again, the differential has to be made up by the company. A variation on the standard, what really commonly comes up is people say, what about this? What if we just make whole the people who got shorted and we don't take money away from people's accounts that got overallocated? And generally speaking, my experience is the IRS will tend to accept that, but for the fact that if some of the people who got overallocations are HCEs, they might not want to allow the money to stand in their account. So because this is a variation on the standard correction, this becomes important to talk to the IRS about and maybe doing a VCP as opposed to a self-correction, because if the HCEs are going to be better off, there's some chance the IRS won't approve that. And again, this just makes the VCP submission more important. because you can't be certain of what's going on. So again, consider the effect of the alternate corrections on the HCE, and then if it gives them more, think about how you can offset that with the IRS. I've actually done situations where I said, okay, how about if we carve out the HCEs from this better treatment, and we'll go ahead and take their money away, but give it all to the HCEs, and the IRS has approved that in the past. Also, to the extent that you're making additional allocations, you got to be careful. Those count as 415 additions in the year for which you're correcting, not for the current year, but the deductions are for the current year. So you want to make sure that you don't have over allocation problems and that you don't have deduction problems when you put those additional contributions in. Okay, so what if you take all this to the client, and the client says, okay, I understand the IRS may want us to take money away from people, but I don't want to take money away from people. And if they make me do that, then I'm still not going to do it. I don't want to do it that way. Well, if you do a VCP correction and the IRS says no, now you're in a funky situation because the client doesn't want to do it, and yet you've disclosed who they are to the IRS, so the IRS can say, fine, if you don't do it, we'll just audit you and we'll make you do it. That's not a good thing. So there is an option under EPCRS where you do an anonymous filing. So you as a practitioner send it in for your client. You do not disclose who the client is, and you throw it up to the IRS, and the IRS then will tell you whether or not they like your correction. If they don't, you can come up with some kind of negotiation as to how to correct. But most importantly, if it turns out that you don't want to do what the IRS says, you can just say, you know what, never mind, and slip silently into the dark, and they'll never know who your client is, and they can't, target them for audit. It used to be the IRS would refund part of your user fee in that circumstance. They don't do that anymore, but you can still do the anonymous filing. The most dangerous part about the anonymous filing is that when you do a VCP filing that you disclose who your client is, the IRS is forestalled from auditing that plan until the VCP is done. So I've had that happen where you got a case in VCP and the IRS targets you for audit, and you say, go away, we're working on a VCP, we'll see you later, and they'll come back after the VCP is completed. If you do an anonymous filing and the IRS comes for audit, what you need to do is you need to disclose that the audit is happening to the IRS. They will send back your VCP filing, and now you have to resolve everything under audit cap. So you run a risk that you're going to end up having to pay an audit cap sanction instead of the VCP fee. So you don't want to do anonymous submissions willy-nilly. You really want to consider the risk of being, having revealed who the client is against the risk of audit while it's pending. Okay. All right. Anybody have any questions on either of those corrections that you want to talk about now?
We actually have several questions that have come in. I don't know if we want to maybe hold these till the end.
Are they about the two corrections we talked about, or are they more general?
The thing that I noticed about some of the questions is they're very long fact patterns, and it looks like people are using this as a chance to get some free legal advice from Eileen. So
I'm shocked, I tell you.
So if there's a quick one in there where they're just asking a technical question about a given subject rather than a full fact pattern, we could probably do a couple now.
Okay. Let's see. The QNEC percentages are based on the EPCRS program. How about if the employer wishes to be more generous and wants to do a QNEC that's equal to 100%?
Well, I don't see any reason why they couldn't do that. Again, it's not a pre-approved correction, but it puts the employee back in the position they would have been. I would think that would probably be acceptable to the IRS, but if they're worried about that, they might want to not self-correct. Or if worse comes to worse, have somebody that they know that knows somebody at the IRS, drop a dime and see if the IRS thinks it's okay.
Okay. And also, isn't there an option to correct a missed deferral without a notice to the employee?
I don't think so, but that person, send me an email and ask me the question again, and I'll look at it and get back to you on that.
And
let me mention something else. I'm sorry. For the people who want to talk about tax situations and stuff, if you want to send me an email, my email address is on this thing. I'm happy to chit-chat with you about stuff without necessarily charging you for it. But if it becomes kind of a big deal, we're going to have to be in a relationship, but I answer sort of off-the-cuff questions all the time for people. So feel free to send me an email and see if I answer.
Here's another one too that I think is pretty good. On the earnings calculations for these corrections, how about using the default fund return percentages?
I think that really is going to depend upon how well the default fund is doing vis-a-vis the other investment selections. Like, it used to be very common for people to use the money market fund when that was the default. And the problem is, of course, the money market fund earns really badly. So I think that the IRS would be more satisfied with an average rate than they would be necessarily with the QDIA rate. But if the QDIA is doing pretty well, then I think there's some reasonableness to that.
Okay. All righty.
Okay, we good?
Yeah.
All righty. Failure to amend. So TVA is taking over the administrative work for MNO's company's 401k plan. Despite the best efforts of the client, the prior service provider, the client's lawyer, the client's mother, everybody else, nobody can find a signed copy of the PPA restatement that was due April 30th. What should we do? Well, this is a document problem. It is not one of the 2 or 3 options for which you can self-correct a document issue. So this has to be corrected in VCP in order to be fully corrected. And I will tell you that document issues are very, very obvious on audit. And I guarantee you that if you don't put it through VCP, if the plan gets audited, they will find it. So this is something that usually we strongly recommend that you VCP it. There are some very special fees if you have a problem with a non-amender during certain periods of time. For example, if you are within 1 year of the expiration of the normal remedial amendment period, the VCP that you would normally pay is reduced by 50%. So if this was before April 30th of 2017 and you submitted it, you would get a 50% reduction in the fee for the failure to restate. Additionally, if you actually go in for a favorable determination letter and you're allowed to do it, and you forget to adopt the amendment, but you do adopt it within 3 months of when the remedial amendment period ended, the fee is only $500. And finally, if the amendment that you didn't do is a good faith amendment, interim amendment, or amendment required for optional law changes, the VCP is reduced to $375. So between all of these, particularly with regard to a smaller plan, the cost of VCPing an amendment issue is really not that high. The procedure and the way they do the forms now is really not that bad. So fixing a non-amender problem is kind of a no-brainer to me. You really ought to just go ahead and file with the IRS. Okay, Scrivener's errors or not. So VWX hires the TPA to take over the plan administration in 2016. The TPA restates the plan onto its prototype or its volume submitter plan. After the plan's restated, the client service manager realizes that there was a mistake and that rather than putting in a matching contribution of 50% like the prior plan, the document was prepared showing 100% match. Oh no. Now, this really perfectly illustrates what a Scrivener's error really is, and that's sort of a term of art to lawyers. It's a situation where whoever it is that drafts the legal document has just made a boo-boo. Unfortunately for us, the IRS does not acknowledge Scrivener's errors for what they are. They sort of believe that the document was signed, the document was reviewed, and it says what was intended to be said. And so you have to go through some special hoops to get the IRS to deal with allowing you to fix a mistake in the document. Okay, what the IRS considers this to be is an operational failure where you didn't follow the terms of the plan, assuming that you have made the contribution based on the 50%, even though the plan said 100%. So what we've done here is that we haven't followed the terms of the plan. And the way we want to fix this failure is to change the plan to match the administration rather than to change the administration to match the plan. So I will tell you that the phrase Scrivener's error is sort of like swearing at an IRS agent. They have a real sensitivity to it. Don't ever use that phrase. I mean, I know that sounds really silly. Like, what do you mean don't ever use that phrase? It's a dirty word at the IRS. Don't use the phrase. It sets their teeth on edge. So the way the IRS looks at this is pretty consistent, actually, with the way that courts have looked at this. And their biggest concern is that the plan document is basically an agreement between the employer and the employees, even though the employees were not one of the signatures to the agreement. And they want to make sure that you don't have employers that decide they can't afford this contribution, so they claim that they actually intended to have a smaller amount. So what the IRS wants to know, really, is, first of all, is there anything you can show us that occurred at the time or that is independent of your decision right now that would demonstrate what your intent was. So for example, let's say that the service provider back in, a year ago when they were first doing their presentation, gave the plan sponsor a chart of provisions and it shows the 50-cent match. Another thing is, of course, you're going to show the prior plan and you're going to say, here we have documents or letters back and forth talking about the fact that we were simply restating the plan onto our document. It had no intention to change provisions, and look, this is what we did. Another possibility is maybe letters going back and forth. For example, you might have that the client considered raising the match, but sent an email to the TPA saying, we've decided against the higher match. Please keep the match at 50%. Now, again, I'm not talking about stuff that was created after we discovered the problem. I'm talking about stuff that occurred concurrently with the problem occurring so that we can demonstrate what intent was based on these documents. The second major consideration the IRS has is what did the employees expect? If the employees were led to expect the 100% match, then the IRS feels kind of strongly like you need to stand by what you told your employees. Now, with a larger plan where the SPD is drafted by the lawyer as well as the plan document being drafted by the lawyer, usually one of the two will have the correct amount on it. In this circumstance, however, if you're talking about a pre-approved document, usually it chunks out of a document system, and so it's very likely that the SPD that was given to the employees matches the plan document provision. So you might have some issues showing the IRS what the employees' anticipation was. Things like hiring letters where you say to the people, we have a 401k plan and we give a 50-cent match might help to convince the IRS of what employees really expected. PowerPoint presentations at employee meetings, all those kinds of things that would show that despite the summary plan description, the employees had communicated to them that the match was 50% would be helpful in convincing the IRS to accept this retroactive correction. New slide. There we go. It's important also to remember a couple of things from the employer standpoint. And the first one is that EPCRS corrections apply only to the IRS. They are not binding on the Department of Labor, and they are not binding on participants. So, for example, there was a court case where a participant took the client to court saying that, gee, I know that you did this EPCRS correction, but I was promised this higher contribution, and the court said that that was what they were entitled to. So it's important to understand that there is still some risk that the client is going to get sued. And perhaps, particularly if it's a one-year mistake, it's better just to bite the bullet for that period of time and make the contribution. Another question is who's going to pick up the cost for the VCP filing or the additional contribution? And it's very possible the employer is going to call the TPA to task. You need to be careful. Remember some basic rules about when you have an error that happens, and that's that most E&O insurance voids coverage if you admit fault to the client before you talk to them. So if this were you, one of the first calls you should make should be to your insurer. Okay, we're running really close to the end of time, so I just want to talk very quickly on the M&A situation here so I can leave some time for the other things that people want to do. In this particular case, we have a situation where employees began participating in the plan after an acquisition occurred. The TPA didn't know about this, and the plan would have excluded them, but they were counted by accident. So it's possible that the plan document didn't include or didn't exclude them. Maybe it did include them, and it could be that you're going to be very lucky, and lo and behold, exactly what the plan said is what was done. If that's not the case, then you've got to figure out what to do with these folks. Moving on, please. You can correct by plan amendment under SDP. No, you can't do that. Even though one of the options for SDP is when you include people early by accident, those early inclusions have to be of people who are otherwise eligible. In this particular case, you have an excluded class. That's not self-correctable under SDP. So you could correct it by plan amendment under VCP by convincing the IRS that the amendment's needed for 410B coverage purposes, or that was the intent of the parties, or that was discussed with the employees, that was what the employees accepted. And so, basically you need to take care of this. Remembering that if you are using the transition period that's available for coverage when you have an acquisition, that any amendment generally is going to terminate your transition period. So you're going to want to take that into account as well. So can we move forward? Okay, if you find an error on audit one of the things that you should try to do before you go forward with the IRS on a closing agreement is see if you can make any argument that the error was insignificant. Because if it's insignificant, the fact that you're being audited does not take away your self-correction possibilities. So that should be, this is what this section is meant to illustrate, is that you should try to make that argument if you can do so and pass the last test. Okay, moving on. Just go past this. Okay, let me let Tim talk about what we have in our e-source. Yo, Tim. Hello, Tim.
Hello,
Sorry,
Tim.
sorry, I had myself on mute.
Okay,
No, it was totally stimulating. Eileen, I was just on mute. So the last 3 slides here, just very quickly, are the specific errors that are handled in Chapter 21 of the book, where we basically go through on an item-by-item basis to show you how to fix each one of those issues. So I'm not sure we have time for questions, but for credit, for ASPA and NIPA, you should get a cert in the next few days. IRPA takes much longer, as it's a process we have to work with the IRS. Please check your spam folders. You will be getting them in a couple days. So please check the spam folder. Questions on credit you can send to us. Otherwise, if you have some questions, Eileen said that she'd be happy to briefly talk them over. There's her email, and there's our email. So at this point, for those of you who are interested, that is the end of the credit presentation. If you want to hang on, we can.
Yeah, thanks, Tim. This is Chuck again. Thanks, Eileen. Great job as usual. Remember, folks, you can download a copy of this, the PowerPoint slides, from either the control panel while it's still up on the screen, or from our website, aristopedia.com/webcasts, I believe. But you can just go to aristopedia.com and there's a link at the top for webcasts. If you can hang on for a few minutes, we're going to give you a quick demo of where this chapter 21 is in aristopedia.com and how it might help you with some of these plan correction questions that you might still have, so you don't have to send emails to Eileen if you don't need to. So just give us a couple minutes, we'll change over the presentation. If you can stay with us, and we'll give you a quick look at that chapter 21.
And Chuck, you should have.
Yeah, hopefully you can see this is the website, aristopedia.com, under webcasts. You'll see our upcoming webcasts as well as the PDF of the slides we just saw and prior recordings. So if you didn't see part 1, for instance, you can see the video of it or get the PDF file of it right here over on the right. It looks like quite a few people are sticking around, so I do want to show you the chapter 21 in the qualified plan e-source, as well as just in general. Aristopedia.com is set up with a number of different treatises. Tim likes to call them books. I like to call them treatises or source material, what have you. We have the qualified plan e-source, which is a 21 chapter, interestingly enough, title, with some appendices, and chapter 21 is all about plan corrections. So a lot of what we covered in the first webinar is this first part of chapter 21. A lot of what we covered here in the second webinar is the specific corrections that Eileen was talking about and the slides cover. So for instance, if you were to look at how to handle the correction of a 401A9 minimum distribution failure, You can open up that section. We actually have it over here on the right. You can see that there's a link to the form that you use to correct the failure, a little bit of discussion about it, a link to the IRS regulation, as well as the EPCRS site. And remember, one of the things that I think that Eileen covered in the first webinar, this revenue procedure that she mentioned that she had the wrong, we had the wrong link up to in the slides. It's actually, I think it's 2016-31, Tim, I believe that's right. Anyway, that's very poorly organized. So what Eileen and Tim have done with this chapter 21 is kind of get things organized very specifically around correction techniques. So you might find this part of the title very helpful. You can always search, for instance, if you didn't know what you were looking for and you just wanted to search for VCP fees, you can always just type in VCP fees, search. Chances are, I got to log back in, but chances are your hits are going to be in chapter 21. So let me do that again. VCP fees. Sure enough, most of these are chapter 21. All these are chapter 21. So you can use the search bar, or you can just open up the qualified plain e-source, go to chapter 21 and scroll down to the specific area that you have a question about. If you're a customer, we appreciate your business, and if you need any help using the product, you can always remember at the bottom of the screen our email is right down here, support@aristopedia.com, as well as our phone number. If you're not a customer, we'd love to help you. We'd also be glad to give you a personal demo or talk to you more about the options. Everything we sell pretty much is a la carte. So please contact us at support@aristopedia.com or sales@aristopedia.com, or call our phone number down here that's on the website. You'll find that also if you go to our main website where we have our products and we have our pricing. So thanks for attending, everybody. Appreciate your time. Like Tim said, you will get automatically get your CE credit, and you may have to check your spam filter, because we do get a lot of people asking us where their CE credit certificate is, and oftentimes it's in the spam filter. But thanks for attending, everybody. Have a great day, and we look forward to helping you.